Have you ever considered transferring your real estate to your children or adding your children to the deed to your real estate in order to protect it in case you have long-term care concerns and long-term care costs that come up in the future? I'm Samantha McCarthy from McCarthy Law in East Greenwich. We serve clients Rhode Island, Massachusetts, and Connecticut in the areas of estate planning and elder law. And this is something that comes up a lot with our clients. So we get asked questions about, can't I just add my children to the deed? Should I leave my assets through probate? Should I do a trust for my property? And it's important to consider the different implications of these things. So for instance, if you add a child to the deed to your property now, it may avoid probate with that property, but you're giving them a gift of equity. And so if you may need long-term care in the next 5 years, that's something that we'll have to undo. And so you won't have any protection. Another concern is that if you're adding your child to the deed to your property now, it becomes an asset of theirs. So that asset could be subject to creditors if they get in a car accident and get sued, or if they have someone slip and fall at their property and they're being sued and their insurance is not enough to cover those claims. Now someone could come after your home as well. The other thing is it becomes their asset. And, sometimes a spouse, if they're getting divorced, may try to claim an interest in that asset. And so it doesn't mean it's never a good idea. It's not never an option. However, it's not always the best option. Definitely worth considering all of the different options so you're making an informed decision. The other thing that comes up a lot of our clients have owned their primary residence for a long time. And so what it's worth now, fair market value with the crazy real estate market, is much more than what they purchased the property for. And oftentimes they don't even have mortgages on these properties. That's what we're seeing a lot with our clients. And if that's the case, your tax basis in your property is what you purchased it for plus the cost of capital improvements. And so if you bought your property for $100,000 and now it's worth $500,000 and you haven't put $400,000 in improvements in the property, which most people have not, that's your primary residence. So if you sell it, it's unlikely that you'll pay capital gains tax. But if you're adding your children to the deed now, you are giving them an interest in the property while you're alive rather than them inheriting it through probate or through a trust. That means they're inheriting your tax basis in the property. So what does that mean? It means that if they went to sell the property after your passing, they would be taxed on the difference between what you originally purchased the property for and the improvements you put into the property and what the property sells for at that point in time. So they're going to take a huge tax hit as well in capital gains taxation. So it's important to consider all of these things and look at what are your alternative options. A trust, various types of trusts, but they're often a really good option to protect the property while you're alive, preserve it from long-term care costs, provide for your children, but in such a way that doesn't detrimentally affect you, whether through creditors, taxation, things like that.